welcome to the 2020 annual update in estate planning and probate. Now, typically what I do is, listen, as we go along, if you have questions, really ask your questions, because some people listen. They'll say, Kenny, you did my will. What should I need to know that's new? I go, just don't spend all your money. Let's spend as much as possible so your kids don't get anything. Yeah. I mean, periodically, someone will talk to me about, saving their assets in case they have to go into a nursing home, and or my wife wanted to buy long-term care insurance. I goes, wait. I've worked so hard my whole life. I shoveled driveways when I was 12 years old. I was a paper boy, delivering newspapers in rainstorms and snowstorms. So I am not going to suffer so that my son, Dr. Brendan, can have a better boat. A better and bigger boat. So last year the big thing was New Jersey did away with the New Jersey estate tax. I mean, I'm sorry, the estate tax. However, there's still a federal estate tax. So for the people in the back row that have $11.5 million, those people got to pay. Everyone else doesn't have to pay because there's no estate tax. And not too many people here in South Edison got $11.5 million. New Jersey still has a inheritance tax, but they also changed that a couple years ago, so there's no inheritance tax if it's going to spouse, children, grandchildren, stepchildren. So that is good. If it's going to brothers or sisters, there's the first $25,000 is tax free. After that, it's taxed at 11.5%. There's no tax that's going to a bona fide charity. So a bona fide charity has to be, a church, a library, a school. It can't be a GoFundMe. You can't make a donation to something that's not a real charity. Sometimes people says, well, I would hate, but there's going to be tax that's due. It goes, well, again, why should you suffer and give away your money right now? Let's see. Also, there's a 3-year look-back period for the purposes of inheritance tax, so it prevents someone who's on their deathbed to say, okay, quick, let's go transfer all this so that my brother or sister doesn't have to pay. Yeah, but again, why suffer? Now, here's something that is like a little bit more of an update, but I tell people, beware. More and more people are doing what's called, I use the word cheap out. They're trying to do their own stuff, and then they consistently screw it up, and they have not saved any money. They have caused more headache, more arguments, more work amongst the family. So just last week, this lady said, listen, my uncle did a new will, I'm the executor, and there's a challenge. And I go, okay, who typed, and he signed it, not in front of me, in front of someone at the bank. So he goes, yeah, okay. Who prepared the documents? I'd say, well, I did, and he signed it. He goes, well, that's why it smells. I'd say, you prepared it. If you or someone would have paid, $400, $500, having an attorney do it, what you're buying with an attorney is not only they'll do it right, but you have basically 3 independent adults who can be a witness in front of the probate judge to say, hey, there was no one in the room, we didn't know this person, they told us what they wanted. But when people do their own stuff, a lot of times it smells, or it's not signed right. And so a will that's done right is good, because all someone needs to probate the will in New Jersey really is the original will, death certificate, check for about $150. You meet with them in a surrogate, everything is golden. However, when it's not done, I tell everyone, plan on spending $3-4 grand, and everyone that would have inherited if there is no will has to be sent a letter. So let's say, someone's like, let's say there's 3 kids, but one of them passed, and all those grandkids would have to be notified. And the whole idea of doing stuff right is doing stuff right and having less aggravation. Okay? Also, one of the things that you want to make sure that your will is what's called a self-proving will. Let's see. Under the old law, person signed and 2 witnesses signed, but then you locate one of the 2 witnesses. And for example, when my grandma passed, they had a tough time locating one of the 2 witnesses, and the lady goes, yeah, I used to work in that law office, I can go to the surrogate, my fees $500. And my dad says, I'm not paying you $500. And he goes, well, then get the other witness. Well, that person died. So otherwise we would have to pay $3,000-4,000 going through the whole process. So the better thing is to, again, the law was changed to provide what's called a self-proving will. So the person signs, 2 independent witnesses sign, the attorney signs, and then it's done again with this self-proving affidavit. So anyone that's done a will with me, I do it right. Now I know an office that they do it wrong. Let's see. Why do they do it wrong? Well, someone said, hey, how come you charge like $400 or whatever for doing a will? This other office advertised they do it for $75. Well, they do it wrong on purpose, so that the person then, when the family calls and goes, they have to pay for someone from that office to go. But that office says, well, we will not charge you the standard. We won't charge you to go to the circuit's office as long as you hire us for the standard rate of 5%. Well, that's called what we call suckers. Let's see. The only time an executive usually gets 5% is either if the person doesn't know any better or they don't want to do any work. I read this book when I was on a trip. It was called Building the $1 Million Estate Planning Practice. But it was really into trying to convince people to have $5,000, $6,000 trusts set up. And when those when the teachers were hitting us in grammar school trying to knock some sense into us about being honest, well, one of the things they knocked into was really not stealing from people. So I really wouldn't be doing the right thing by telling my best man's mom, oh yeah, you need a $5,000 trust packet, when a $400-500 will would be just as good. So anyway, I remember running into the law guy from the law office that did it the old way so they could charge people money. And I remember saying, Willie, you guys are gonna get in trouble for doing that. That's like a doctor only doing not doing the surgery the whole way, hoping they can bill the insurance company a second time for a follow-up. I'd say, I'd say, he goes, well, if someone wants a self-proving will, we will do that. I goes, well, how many people in Carteret know what a self-proving will is? Nobody. And most of the, half the attorneys don't know what a self-proving will is. Now, here's something else that the will should say, and that these cheap things online do not say. It should say, no bond required. If there is no will, then a bond has to be taken out. It's like an insurance company, but figure on paying $1,000, $3,000. My wills all say no bond is required. But if there's no will, or the will was not done right, these cheap things online, then they got to pay this bond fee. The whole idea of doing it ahead of time is trying to make it as easy as possible, so there is less work, less aggravation, etc. Let's see. And some people can't be bonded. That's one of the problems with people not having wills. There could be 2 kids. They don't have good credit, and therefore there has to be a bond. Mike, I told Steve to come at 5 o'clock, so he should not be in here. And someone else needs that seat. So, if you have an old will, if it was not done by me, it has to say, make sure it says no bond required. Let's see. If it does not say no bond required, then get a new one done. Let's say if someone doesn't know where the original, let's say you have a relative that's, I can't find my original will, get a new one done. Let's see, retired gentleman called us the other day, says I can't find my will or any of my documents. Now, he may have been similar to my father-in-law, that all of a sudden they go into assisted living and they don't have all their stuff because they're not in their house anymore, and the family has secured it so that it's not in a room that's open all the time. But my office says, a rule of thumb, if you can't find your original will within 72 hours, get a new one done, unless you can guarantee that you're going to live another 72 hours, which never happens. Let's see. A photocopy of the will is as good as a photocopy of a $20 bill that you lost. Let's see. Think of the surrogate as a fancy name for the will clerk. Let's see. If you have the original will, death certificate, check for $150. You go in with your ID. The circuit goes, okay, here's your papers, and that's how easy New Jersey probate is. A photocopy, though, has to go through a big, giant, long process in front of a superior court judge. and everyone has to be notified, and there's a presumption if the original can't be found, the original was ripped up by that person. So, one of my Elks brethren, there was a fire, there was actually an explosion at his next door neighbor's house, but then his house caught on fire, and that meant that there was, everything was burned out. Well, I had on my computer, said, listen, Mr. K, come in, we're just gonna sign new documents, I'm not gonna charge you because you had enough, tragedy, losing your wedding album and all your other stuff. I just changed the date. Okay, something else new, funeral agent. Let's see, funeral agent. Let's see, the will should provide for, and funeral agent, and also you should also have, something written down that sets forth who's going to be the captain of the ship. Why is that important? Well, let's see. You're going to try to make things as easy as possible for your family. I was at a wake of someone, and I was at one of the two places I'm a touch. And I go, by the way, said, let me have your price list, and I got it, and I filled it out. Okay, cheapest cremation, and that way. It's done, and in my will it says, okay, funeral agent is executor 1, funeral agent executor 2, but in one of the matters, they could not bury someone because there was no writing, that's because the person did not have any children who was the captain of the ship. And the funeral, they couldn't get a death certificate because, the person had died at home. Whenever someone dies at home, there has to be a whole, there has to be an autopsy. They got to, the coroner, because they have to make sure that someone was not put out of their misery. There was about 10 years ago. There was the male nurse doing mercy killings of people, and sometimes it was people that were going to be released. So make sure there's a funeral agent. Many times the wills online are not done right. Don't believe that just because some online company charges you like $50 and they type in valid in any 50 states. What is valid also might not be best for someone. Let's see, New Jersey's a probate easy state. Let's see, sometimes people come in and go, so I want to get a trust done. My mother-in-law used to always, I want to get a trust done. And I said, were you watching Susie Orman? She goes, oh yes. Susie Orman is exactly right. If you live in New York or California, Florida, you want to have a trust because the process is very, very complicated. But New Jersey is an easy state. So I tell people, listen, if you're here in New Jersey, you don't need, you don't need to have a fancy trust. If you have property in Florida, it would be a good idea to put that property into a trust, so the family doesn't have to go through the lengthy probate process of that. So some people have condos in Florida or second homes in Florida. He goes, listen, put it into a trust there, and their process is very complicated. Of course, trying to tell that to a 92-year-old World War II vet that's what they should do. They goes, no, I'm not doing that. I don't trust you guys. And say, and the whole thing. If I know most of the people over 23 years old here already have wills. If you don't have one, get one done. That's it. And sometimes people also, they say, I want one fellow. Well, I want to read up on this. So I goes, this. You don't need to read anything. I'd say that's why I read. I go to seminars, I wrote a book on this. You don't need to read anything. When I need a knee surgery, I read nothing all about how the doctor was going to do the knee surgery. I don't want to know. Doctor, have you done a knee surgery before? I asked the knee doctor. Now, he was he was referred to me by the Rutgers track coach. He's done thousands of he's done professional athletes and stuff like that, but he said, yes, I've done this before. Okay, I'm good to go. That's all I wanted. Just knock me out. Let me know when I can start running again. I don't want to know how it's done. And ironically, the guy who kept on wanting to read about stuff, when he passed away 2 years ago, the family found letter we sent him in our business card, wanted to know if we had the will. He goes, no. He wanted to read more and then didn't want to pay for us to give him a third consult. So I goes, hey, listen, don't come back. Even if you already have a will, sometimes there's periodic review that you want to do. Okay, can the executor still do the job? I'd say yeah. My rule of thumb on the executor is, can they walk up the 4 steps in front of our office, and can they drive to the circuit's office? It's not that we're anti old people or people that have bad legs. There's work to do. Let's say, and if executor number 2 is moved out of New Jersey and they now live in Sacramento, maybe that, sometimes you don't have anyone else, but sometimes that's not the best person. Sometimes I did a seminar for the state bar, a webinar. That's where people pay them and they listen to us guys talking. But it was estate planning for the we don't want to use the word wayward child, but it's really for the difficult child. We changed it to one that has financial problems, substance abuse problems, alcohol problems, whatever. People that have special needs kids know that they got to do stuff to protect those kids. Or sometimes someone has they have a special needs grandkid. Listen, I don't want any money going to that kid because then when they turn 18, they'll go and blow the whole thing. But as difficult as it is, sometimes we don't want someone who's 40, 45 years old, 50 years old to get money because they will blow it and other people will influence them. There was a I represented an estate. Mom had set up a will. Everything got divided amongst the 4 kids, except the money for one of the kids was in a trust, and the kid was 45, 50 years old, and his ex-wife had filed a motion in family court asking that the court compel the trustee to pay all the undue child support, all the undue alimony, etc., etc., etc. And I said, Judge, the reason why we set up these it's called a spendthrift trust within a will, the reason why we do that is to protect all the assets. The sole discretion is in that trustee so that someone doesn't get chunks of money, and we decide where the money is best used for that person. Because if you give an alcoholic $100, they'll buy $100 worth of booze. You give them $1,000, they'll buy $100 worth of booze and give away the other $900. I'd say
Now, how much does that cost?
I'd say
that type of trust.
I'd say I usually I'll usually add it with. It's not a separate trust because a separate trust, I tell people, listen, that's when you're getting tax ID numbers, you're funding it right away. A separate trust is usually $3,000 a pop. When you're setting up trust within the will, I usually say, listen, I'm depending upon how much work, it could be 300, 400, depending on how much work I got to do, because people, law is not like going to a McDonald's where there's a chart on how much everyone is. And sometimes the new staff people goes, how come we don't have a price chart? He goes, okay, because I said, okay, here's the pay. You tell me how much work I got to do. And they say, I don't know. Me also. Some people have I don't have any children, but I got 5 brothers and sisters, nieces and nephews, friends, and what I've started to do now, which I don't know why I didn't do this years ago. We always email out the questionnaire. I go, listen, if you got a computer, make everyone's life easier. Type it up rather than taking a crayon and because even when Bala Subramanian came in and all his the wife had a different name and and I can't read the handwriting, that was difficult. Nowadays, when someone types it up and then emails it to me, I got it in front of me, and I'm actually cutting and pasting. So when the client last week had said there's spelling errors in her will, I goes, yes, that's because you spelled her names wrong. And no big deal. That is an easy fix. But what I also am saying now, goes, someone said I'd like to changes to the will. It goes, if it is changes to the substantive portion of the will, the legal stuff, no, I'm not going to make any changes. Let's say let's see, if the electrician does work, let them do the electrical work, and don't try to do it on your own. Yes, ma'am.
A perfect case for you. I'm recently divorced. I have a will. There's not much to change in it except for ex-proof it.
Except what?
Ex-proof it.
What's that?
I mean, the X was I have to redo it to lose the X.
Yeah.
So presumably that's a perfect case. It's not too much work.
Yeah, but also one of the things you want, typically, that person was executor one, executor two.
No.
What we also find when people were married and get unmarried, a lot of times they had a power of attorney. And the power of attorney, because typically most attorneys, when they're doing the will, they also did a power of attorney. The power of attorney is a document that gives someone the legal right to go into the bank and withdraw all the money. Let's see, never assume, so I
I'm a
tell.
stockbroker, I don't think I have that.
Well,
Don't.
never, right,
We'll talk.
never,
Never
assume,
Never assume.
never assume. I wrote an article for the American Bar Association because sometimes they say I have nothing to do. Those really, you hate saying no. Hey, can you do an article? You wrote a book. Can you do an article on this? Yeah, the article is on estate planning for the separated person, and they say, listen, you got to do a new power of attorney. We're not even talking about divorced people, separated people. I said, listen, put a hold on those accounts, do a new power of attorney, and then send something to all those other entities, any place where you had money, saying the power of attorney that I gave to, spouse, or ex is no longer valid because I'd say, I don't handle divorce cases, but usually most divorces are not a handshake. Goes, hey, everything was great. I didn't even know why we got divorced. I'd say, so I'd say we send notices out, and you got it. And I also tell everyone, get printouts of who your beneficiaries are. I'd say on your, because a will can't change who's the beneficiary for accounts if you have beneficiaries already. So now by operational law, if someone gets divorced, that spouse is no longer on the account. However, how is the that institution going to know that that spouse is unmarried? Everyone should have next to their original will the printout of who the beneficiaries are. This way you're making the executor's life easier. I was married 15 years. I found in my life insurance still have my dad as the beneficiary. I'll say, yeah. I'm sure my dad would do the right thing. He wouldn't steal the money from my wife, but yeah. For the people
It
that
happens.
yeah, I'd say yeah. A lot of times though, your adversary is not your own blood. It's whoever they were married to. I'd say yeah. Mr. M probably should have had a trust. He was 89 years old and said, you know what, I'm just going to give my money to my son and my daughter. I love them both. They love me. And so he just, we just like, half of his money went to the son, half to the daughter, did a new deed. Half the house was to the daughter, half was to the son in case he had to go into nursing home. He goes, listen, I know I got to live 5 years, but, I'd just rather have the money now. Okay, everything's good. Probably should have trust. Son dies. Who owns half of all his stuff now? His daughter-in-law or his ex-daughter-in-law. I'd say.
Yes.
So the family sent a letter to the nice ex-daughter-in-law. Can we have our money back? I represented the ex-daughter-in-law. He goes, what do I got to do? He goes, well, you can tell him to go screw. I'll do the letter for you. Now what we did do was we gave back them a chunk of money and put it up into a trust for the benefit of the old man. So in case, he needs it, because he was still getting some pension money, some stuff like that. But, we knew if we would have cut a check, we'd get him half the money. The grandkids would have never seen anything.
Everything, yeah.
Anything. All right. Let's see. I mentioned the federal state taxes. Okay. Power of attorney. Okay, we talked about wills. Does anyone else have any questions on wills before I go to power of attorney? Except the law clerks. Yes, ma'am.
Yeah, I have one question. I do have a will made up about 25, 30 years ago.
Get a new one. Next.
And
Good question.
since then, my daughter is in my will, but she has remarried and she's going back to her maiden name.
Okay.
So do I need to have my will?
Okay, so the question is, if someone's name changes, do you need to have a new will? The answer is no, but I tell people, listen, if a will was done 25 years ago, it may have been done the old way, where your executor got to locate one of the two witnesses. And, I've had people come in and he goes, oh, that, they go like, oh, I see the will was done by Carl Meyertens, and it was done the old way, and he's dead, and whoever was working for him 25 years ago, same thing, probably, is not, obviously not in his office, because he had his own office, get a new one done. Let's say, it is better to spend $400 or whatever to get a new will than to have the family be aggravated. It is an investment. Let's say don't wait until the light comes on your car that says check engine because you hadn't had the oil changed that year. Let's say by that time you need a new engine. Let's say anyone that tries to do us guys. Do you remember when we were younger and our father taught us how to change our own oil, and we did it for a bunch of years. Then all of a sudden he goes, "What am I doing this for? Someone else can do it faster, cheaper, and they'll do it right." I'd say I worked in one of my quality jobs. Like I graduated actually early from college, 3.5 years. So my dad says, "Good, great, come back and get a job here." I goes, "No, I want to stay in Scranton, University of Scranton." So I get a job at a gas station. Lady comes with a new car. Goes, "It says check engine light." "Oh, that's not good." I'd say, "Yeah, I need oil." "Okay." I said, "Lady, I don't know nothing about cars. I'm just pumping gas." And she goes, "I think it's this one." So, okay, open up the old oil can. Like I had to use the funnel through the metal thing and put in and some went in. All of a sudden, it started coming out. He goes, "This is not the oil. This is not the oil area." So, don't do your own electrical work. Don't change your own oil. Don't try to do your own legal work. Don't try to do your own accounting work. I'm not an accountant. I don't do accounting work, but the same thing. I haven't done I tried to do my own tax returns about 30 years ago. My wife and I were first married, and using the kit, and my wife starts crying. Goes, "We owe $1,100, and we bought the house using credit cards." And we didn't need the money, because we want to get the house. Okay, because we don't have $1,100. We don't have $11. We owe the credit card. So I redo it, and it says I'm getting back $900. Good, quick, let's file this one. Let's see. And then 2 months later, we get a check from the IRS, a refund check. It's for $5,000, and it says explanation will follow. And now we're worried. What do we do? What's depositing? And then we get the explanation. Math error. And it's listen, I tell everyone this. You kind of know ahead. You want to kind of know ahead of time before you buy. Okay, let's talk about how. Oh, yes, ma'am.
Can you quote me a price and how much?
We usually charge like $400, $500 doing what we call a basic will. Okay. We provide the witnesses and we do it right. Okay. Yes, sir.
Ken, quick question. State of New Jersey, is it a law that if a married couple and one of the two dies, with or without a will, everything will go to the surviving spouse?
So in New Jersey, if the question is if one of the two spouses passes, does everything go to that person? The answer is yes, as long as all the children were from that relationship.
With no children.
With no children. So it goes to the surviving spouse. But I also say, that is not doing that's not doing estate planning, because you still got the issue on who's going to get it next.
Yeah.
Let's see.
But once one of us die, our spouse, we still have to get a new will.
No, because typically your will usually says, every will that we do has what's going to happen if someone's got. It's kind of like those math things. If this goes here, so I call it the basic American will says if everything's going to spouse and to children. Sometimes sometimes in second marriage situations we don't have it going to the spouse, because then that means they get it and the kids get nothing. But people will sometimes say, "Oh, we're giving it to each other, and then we have it split equally between our two families." Goes, "No, do not do that. That's the wrong way." Why? Well, goes, "Well, the day after you pass, they're going to do a new will and says your kids aren't getting anything." Did that answer your question?
So if one of the spouses has children from a previous marriage, then in the will that you put together, you have to designate what those children will get
Who's
as well.
who's typically who's gonna get stuff.
Yeah, okay,
You know,
alright.
now I don't when it's the traditional American family where it's from the same relationship. Someone says, "Why aren't my kids named?" I goes, "Is there any dispute who your kids are?"
Yeah.
Okay. I'm trying to do less work and not spell people's names wrong, because then it gets to that issue of what if someone's name changes. That's why we don't. The names go in who's executor 1 and who's executor 2. However, let me talk about power of attorney. I recommend if someone's name has changed, they get a new power of attorney. If the name has changed, address has changed, get a new power of attorney. Not because I'm making a whopping extra $75 or $100, but if someone goes to a bank and they have a power of attorney, goes, "Listen, I got mom or dad's power of attorney, I need to do something." "Okay, do you have the original?" "Yes." "Can I see your ID?" "Yes." "Well, this is something else." "Well, oh, that's my maiden name or that's my new name, whatever." I go, "Well, we need something that says that this is still good." They give you a hard time. "Yes, ma'am."
My understanding is power of attorney is only good up until the day the person dies.
That's correct. The power of attorney ends the day someone passes.
Right.
Now, if you don't have a power of attorney already, get one now. Let's say that includes you college students, because no one has a right to help anyone else out without a power of attorney. That's a nice way of putting it. Let's see. We get college student falls down and they break their arm, break their leg. Let's see. The doctors can't talk to that parent. The parent can't access anything. The parent can't talk to their college. They can't talk to anyone. And most parents kind of want that control anyway, over stuff. We get calls all the time. "Oh, I need to get power of attorney from mom, dad, Uncle Joe, whatever." No, you can't. You can't get power of attorney over anyone. Only they can give it to you. Let's see. I was referred a case last week by an attorney, and it goes, "We can't do a power of attorney for someone that we haven't spoken to." If someone can't come in, I've been to care facilities, but I need two things ahead of time. Number one, if they're that ill they can't come in, I want to know from a doctor saying that they're okay. Simple form. The level for competency is really low, but I'm not going to make that judge. Let's see. Number two, I want to talk to the person first over the phone and confirm that that's what they want, and not what a family member wants. Okay. And then we do email out the form, but I want to talk to them first because I remember when I was first starting out as a young lawyer, and you're happy for any kind of new work, and fellow says, "Oh, Dad wants to have a will and also wants to sign a house over to me, etc." So, okay, good. He can't come in though he has a bad leg. Okay, fine. I go to the house in Edison, and I remember it was our first nice day of spring where the sun's finally out, snow melts. I see the robin chirping away, and the son was waiting outside the house because he doesn't live there, and the son brings me in and says, "Dad," I said, "this is an attorney. He's going to explain to you why you should sign a house over to me." Old man goes, "What?" "Dad, this is an attorney. He's going to explain to you why you should sign a house over to me." Old man goes, "I'm not going to sign a house over to you. You'll sell it and kick me out." And that's when I realized that obviously he had not told Dad that he was trying to pull a fast one. So if it smells, I don't do it. I'll say Johnny calls me up. "Listen, Mom wants to sign a house over to me. She's on oxygen tank." Okay. Doctor signs a note. She's okay upstairs. She fills out the form, but then the next step is I call her up because I look at the form and goes, "Okay, Mrs. B, tell me what you want to do." "I want to sign a house over to Johnny." That's what she wrote down. "Well, Mrs. B, I understand if you sign a house over to Johnny, the other two don't get anything. Is that what you want?" "Oh no, I want all my children treated equally." "That's what I thought, Mrs. B. Put Johnny back on the phone." So again, I want to be comfortable that it's what that person wants, not what that person wants. Let's see. And that's a rare time when Mrs. B would have been better off putting the house into a trust rather than because if just signing the house over to the kid, they don't own it anymore, and then the kid can kick them out. Would that happen? Well, let's see. If they sign the house over to the kid and then that kid passes away, their spouse is that now owns it and then they're going to be influenced by their new spouse.
Yes.
Hey, kick mom out, let's go sell the house, we'll use that money and go on some trips and stuff like that. Okay, so the power of attorney is either effective right away or only upon disability. Most married people make it effective right away. Most people make it effective right away, because otherwise you got to go and prove someone is disabled. But one of the clients come in and goes, Kenny, you're talking legal stuff. He goes, I'm a carpenter, use carpenter language. Okay, if it's effective right away, your son can still owe your money right away. If it's effective only upon disability, your son has to get a note from a doctor saying you're disabled before he steals your money. Okay, do you trust your son? Yes. Okay, then sign A. Let's say, again, going back to cheap stuff online, there was a change in the law because some of the banks were giving people a hard time. They would say, oh, it wasn't done on our First Fidelity form or Wells Fargo form, so we don't have to honor it. So the legislature came up with a law that said, listen, if it references New Jersey statute and they do any business in New Jersey, they got to honor it, otherwise they're in violation of the Department of Banking rules and regulations. However, the document has to make reference to Section 2 of PL 1991 C95:46:2B-11, and I'm pretty sure something free online is not going to say that. Not say it. So that's why. And let's say someone is incapacitated. There's no power of attorney. Well, then the family got to spend $4,000 or whatever doing a lengthy, expensive guardianship. And a guardianship is a very, very sad proceeding where first you got to get 2 affidavits from doctors saying that they've examined a person. The person's basically, no longer able to take care of themselves. And it's kind of sad because, you're kind of airing the whole family dirty laundry. And then a complaint in order to show cause got to be filed in the Superior Court. Then all the children got to be served with a notice. And sometimes you got, one of the reasons we're planning ahead, sometimes there's the kid that wasn't involved when they were needed to be, and all of a sudden they come out of the woodwork and they're putting a wrench in. Let's see, so all of a sudden they goes, oh no, I want to be in charge. Be in charge. We haven't seen you for a year and a half. You don't get to be in charge. So a power of attorney a lot of times avoids having to go through the whole guardianship. Part of doing planning again is so that the people that you want to make sure are handling stuff are there. And one of the clients said, do I have to treat all my children equally? No, it's your call. If you want to leave everything to the Yellow Dog Society, you can leave it to the dogs. I'll say, I go, what's your issue? He goes, well, one of my sons we hardly hear from lives on the West Coast. Well, let me ask you a question. On your birthday, did you get a card or a call? No. At Christmas, did you get a card or a call? No. On Mother's Day, did you get a card or a call? No. So your question is whether or not they should get anything at all. Let's see. Or give it to the people that right now are care about whether or not you're alive or not. Let's see. So that is someone's call on what they want to do. Because we also find sometimes the one that wasn't involved all of a sudden, like when someone's in a hospital, walks into the room and goes, okay, I'm in charge now. Remember when Reagan got shot and General Haig went on TV and goes, okay, I'm in charge now. Well, not really. You're way down on the constitutional list. So if you don't have a current power of attorney, get a new one done. The last thing we want to talk about is the Living Will Advance Directive. Let's say what law came up a couple years ago, the HIPAA law, which meant that doctors could not talk to anyone about anything unless there was something in writing. So mom was brought in by daughter, let's say on a Wednesday afternoon, and the doctor says, sorry, I can't talk to you. What do you mean, doctor? I've been bringing mom in for the past 10 years. She doesn't drive. Yes, but the federal government says I can't talk to you unless there's something in writing. Let's see. So we changed all of our powers of attorney, all of our living will to have a HIPAA authorization to say that doctors can talk to them. But we also want to do is similar to the will. When a will is executive 1, executive 2. Never have joint executives. That creates twice as much work. Someone says, I got 2 kids. Okay, that's nice. Someone's number 1, someone's number 2. If you have joint, you're creating twice as much work. Let's see, I told people, and if someone says, I want all 3 together, he goes, no, I won't do it because that's stupid. That's going to cause problems and they're going to blame me. Let's see. If someone says, I insist upon having 2, I goes, hey, listen, that's your call. You can insist that the electrician use aluminum wiring, even though they haven't done that for decades, because that's the bad cheap kind. But so in the living will advance directive, let's see first, and we have copied word for word from what the medical society has. So when someone says I'd like to change their wording, no, we're not going to change the wording because this is what the doctors are familiar with, and that's why it's called a legal document and not a do-it-yourself document. That way the doctors know. So the first section, think of the living will as someone's in a coma, irreversible condition. There's no hope for them, and we don't know, what to do. Okay. So what we're doing is we're giving instructions to hospitals and doctors, like saying, okay, listen, there's no hope for me. You're in a coma, irreversible condition. We are having, this person as number 1 to talk to, number 2. Then there's boxes to initial. Let's say someone's in a coma. Fluids and nutrition, yes, or fluids and nutrition, no. Let's see. Nowadays, probably 80% of people say, "Listen, there's no hope for me. No fluids and nutrition." Ironically, in my first one, I put down I wanted fluids and nutrition because I was on high school wrestling, and I remember not having fluids and nutrition or eating for days at a time. Because the coach goes, "Kenny, lean and mean. You're going to be our 10. You're wrestling 101." Coach, I'm dying. I don't. How much blubber is there on a high school sophomore that has just finished cross country season? Not a lot. Not a lot. I think all my bones were empty. All the marrow got taken away. But the idea is, and so I remember saying, "Oh, look, provide fluids and nutrition." Then I went to the other extreme. Listen, if I can't run anymore, I want to be put down like they do to racehorses because I had not missed a day running for 15 years, 11 months. And then he goes, well, you know what? Maybe I don't want to be put down right now. I still got some more good years, at least walking and doing stuff. And then went back to running after the doctor said, you're not running anymore. And when I had my second knee surgery, he goes, run less. First one, he goes, you're not running anymore. Second, it's kind of like saying to the lion, the vet goes, listen, you got some issues with your stomach. We want you to switch to a diet of, fruits and vegetables. And the lion goes, hey, listen, I eat meat. That's what we do. We're lions. You tell a runner, hey, we go out and run. Okay, the next section in the living will is like the one that is the directive as to medical treatment. Oh, did I ask you if there's any other questions on power of attorney? No? Okay, good. Okay, so directives as to medical treatment. 99% of people said, listen, if there's no hope for me, I don't want to be on machines. I don't want to be on respirators. If I'm brain dead, there's no hope for me at all. Let's see, only 2 people. I can only the other one. Number 5 basically says none of the above. Let's say you want to be kept alive forever. Let's say one lady came in. She goes, I need to take my husband off the deed. Has an old copy of deed. Okay, we prepare a new one, but when can he come and sign? He goes, I haven't seen him for 10 years. He goes, well, you just can't take his name off. And he goes, okay, I'm looking at the deed. I goes, well, do you understand that if under this deed you're still married, it goes to the survivor? What does that mean? He goes, well, if you die tomorrow, he gets it. He goes, well, but I've been paying the taxes and mortgage and upkeep for the past 10 years. I haven't seen or heard from him. He goes, well, if you die tomorrow, he gets it. So either you get divorced and he, and there's an order, or he signs a new deed, or he dies before you. So she said when she says, okay, well, let's at least do the living will now, but I want to be kept alive 1 minute more than him in the event that so that I get the property. Let's
Oh,
see,
jeez.
1 minute more. Let's see. And now, it is a good idea to give copies of the, not the original, but copies of the living will to your doctors, your hospital, etc. A lot of places now are scanning, because whenever you have to go to the hospital, there's a question: do you have a living will? Yes or no. Even you go to like the Medi-Merge. Do you have a living will? Yes or no. If so, we want to have a copy. The last time I had knee surgery was at their same day surgery center that University of Orthopedics has. So I checked off no, because I don't have to go and find it. But I'm also saying, listen, if I'm going in, I'm a pretty fit guy. I'm going, I shouldn't be in a coma if I'm going in for 1 hour surgery for them to do a procedure on my leg. They're not doing a brain transplant. Now, only the original will can be admitted to probate. Let's see. So the original will should be put in a place where executor number 2 can get to it. Let's see. In a place, if you're not treating everyone equally, where the people who aren't getting what they consider their fair share can't find it and rip it up. A good place, people go to Costco, they buy a fireproof box, put it in the fireproof box, throw it under the bed, and then let everyone know this is where it's at. Let's see. Make sure the box is closed. Let's see. My wife bought a fireproof box, but she had so many papers shoved into it, they're all sticking out the side. I go, that's not fireproof, that's called kindling. And there's old envelopes and stuff like that. Get rid of the junk. Part of the planning is make it as easy as possible for the people down the road, so they're not going through stuff. Let's say if you sold a house 15 years ago, then you can get rid of those papers. You don't need to hold on to them. Let's see. If you don't hold on to your old wills, if you had a new one done. Let's see. Get rid of as many things as possible, because otherwise you're burdening the family. Let's see. When my mom passed, that's not stuff that someone wants to see. My mom threw out nothing. When she passed away in October, she had my letters home from summer camp from the 1970s. My letters home from college, my letters home from law school. It was very interesting reading it, because there was a common theme. Let's see, please send money for food. That was the whole other theme. Every letter said, send money for food. It's like, because college didn't have any money. Please send, college. Please send money for food. Law school. Send money for food. Let's see. I mentioned only the original will can be admitted to probate. Sometimes it's if everyone's being treated equally, you give, you can give, if you want, you can give a copy to the whole family member, just so they know that it gives them some feeling that, okay, you've taken care of business.
But you don't have to give everybody a copy.
You don't have to give anyone anything.
Okay.
And when someone calls us up and goes, do you have a copy of X? We got confidentiality laws. We can't talk to anyone.
I got a question on that.
Yes, sir.
Go ahead.
So, I was an executor on a will recently, and once the will is probated, you have to send a copy to everyone that's listed in the will.
After, yeah. So
Mentioned
when
in
someone's
the
an executor, there's a statute that said you have to send a notice of probate to everyone saying the executor is this person, that person's address is here, was admitted to probate on this date, in the ex-surrogate's office, and the letter says a copy of the will be provided upon request. In my office, I tell the executor, listen, let's just send them a copy of it so they don't have to wonder what's there.
Second question, do you have to share the financials once you settle out the estate?
You do not have to, you don't have to share the financials with people that are not getting a percentage.
If they are.
If they are, because they have to be provided with, at the end of it, so let's talk about probate, okay? Probate in New Jersey is relatively easy. I mentioned you bring your death certificate, check for $100. Think of the surrogate's a fancy name for the will clerk. They give you the papers. Okay, what do we have to do next? Well, even though there is no New Jersey inheritance tax, if there's real estate, we still got to get a inheritance tax waiver and from Trenton, and we have to then file it with the county clerk with the cover sheet and like three other documents. Let's see. The executor does their business. I tell most executors, listen, let's say we can help you out. What you can eat, the work that you do, you don't have to pay us for. A lot of stuff you can do on your own. Some people like that are not are executors, but aren't getting a chunk of the estate. Say, listen, I'm gonna let you do more of the work because I don't want to be aggravated by these people. Let's see. But in the end, the New Jersey statute says that there has to be an accounting approved by the judge, or every beneficiary sign what's called a release and refunding bond, saying you're satisfied by what the executor has done. We are, and I know I'm getting approximately X amount, and then that release and refunding bond has to be filed with the county surrogate, and nobody gets their money until everyone signs. Let's see, and now on the other hand, I tell the executor, listen, you're gonna have to give them a formal accounting because who's gonna sign stuff where they're not getting? I said an informal accounting. Who's gonna sign stuff if they're not getting an informal accounting? I wouldn't recommend someone sign that. Please trust me, but I'm not telling you what the finances are. The better thing for most executors is I tell my executors, listen, once a month, everyone gets an email saying this is what's going on, and that way people don't, can't complain. I'm in the dark. I haven't heard anything from this person. So. We're not talking about, most people will do an Excel spreadsheet or make copies of the bank statements. They can send them out to me so they know that there's no secret. Please sign. If everyone, we send out the release and refunding bonds to all the beneficiaries. You're getting, you previously got the account, the informal accounting. You were emailed the release and refunding bond. I'm sending you the hard copy, signed in front of a notary, and returned to us by February 2. Let's see. If everyone doesn't sign by February 2, and it got to be in front of a notary, if everyone doesn't sign by February 2, then we send out another letter saying we have gotten the release and refunding bond signed by everyone except for brother X. If brother X does not sign, then we're going to have to go through a lengthy and expensive proceeding called a complaint order show cause for accounting. It's going to delay everyone getting their money for 6 months to a year, and nobody gets their money until that is signed, or there's a court order. And then the letter says like some of you may perhaps this person does not understand the importance of this. You may wish to contact them. Here is their phone number, their email, and their address. That way people can knock on the door or bother them, saying, listen, go and sign the thing. You're delaying me getting my money. Because the people that sign goes, well, why can't I just get my check? I signed it. Because the good book, say not the Bible, but in law, the court will say, thou shalt not get their money until it is signed. End of story. It's either signed or some people, well, I can do everything on myself. I don't need an attorney, etc., etc., etc. Okay, fine. Two ladies came in. They were co-executors of Auntie Whatever's will, and they said, listen, we just got in this letter from the Division of Human Services saying we owe, the state owes $89,000 because she happened to be in a nursing home for a period of time. I go, well, I goes, we gave out the money to everyone. I goes, well, that's why you had everyone sign a release and refunding bond. I'd say, because that means that they're gonna refund the money to you so it can be paid. He goes, oh, nobody told us we had to do that. He goes, well, who was gonna tell you? You represented yourself. You said we're not gonna spend any money on a lawyer. We're gonna go and learn and know all the rules ourselves to save some money. That means, I said, you as the executors have to pay. Of course, you didn't comply with the rules, with the statute. Or you can get the people to voluntarily give their money back. But, that's why my job when I represent in an estate, I don't represent the estate. I represent the executor. And to steer them in the right direction. occasionally beneficiaries will call us and I goes this, let's see, let's see, we try to be nice to people, but one person said, let's say you represent me. He goes, I go, no, I do not represent the estate. I only represent your brother. That is the only person I represent. Let's see, so that is why it is important. No, and so let me go. That brings me on to a last quick point on when you having the attorney do a will rather than no will. Let's see, if there's no will, it's a mess. Listen, there could be 3 brothers and sisters. They get along together. We are sure that but that still means that 2 people got to sign what's called a renunciation, saying, I waive being the administrator of the estate, and I have selected this person to be the administrator, and then it got to be filed with the surrogate with a fee paid.
What's the difference between probate court and surrogate?
Oh, well, sorry, think of surrogate and probate court as the same animal. The surrogate handles the paperwork, whether or not there's a will or not a will. So I like to say the surrogate. Think of surrogate as a fancy name for the will clerk, but they do the other stuff in connection with probate matters.
See, that always confused me.
So,
okay.
If there's a will, the person who's the captain is the executor. If there's no will, the person who's in charge is the administrator. But one of our Edison estates, there is there's 3 kids. The daughter lives in North Carolina. She's not around here. There's a house that got to be sold. The oldest brother lives not that far from here in Central Jersey. And the brother number 3 is in New York. So the sister signs what we prepared as a release, the renunciation for administrator and saying I want the brother. She signs it for the notary, gets it back to us. Let's see, brother number 3 in New York says I'm not going to sign that. I want to be the administrator. Brother number 3 is in prison in New York for conspiracy to commit murder. Let's see, he can't be this, but without that brother signing the renunciation, let's see, that means we got to go through the whole expensive complaint order, show cause, etc. Spending thousands of dollars. So, no will, spend thousands of dollars, and have everyone have aggravation. Let's see. So, we've never had anyone after doing a will say, "Oh, I wish I didn't do that." It's not like buying, I wish I didn't buy that car, I don't really like the color, or I wish I would have test drive it, I don't like where the gadgets are. Everyone's like, okay, good, I'm glad I finally got that done. I'm seeing people with old stuff, I've been putting this off for, a lot of years. Yes, I see you've been putting this off. Your son is 40 years old, so you've been putting this off for 39 years. Let's see.
Many people make you the executor
the only
of
time
your will?
the only time I am the executor is if they put down in writing that they say, listen, I do not want to have this child or these people as the executor because I don't think they will do the right thing. And I know that you have a legal obligation under the rules to do the right thing, plus you're smart enough to do the right thing. Well, see, some people don't know any better. There's some people that are executors and money's supposed to be held for someone until they're 21 or whatever age. They don't know any better, they cut them a check. Let's see. Or they give them the money when they're 18. The reason why we have clauses in will saying no one gets any money until they're at least 21 is how many 19-year-olds or 20-year-olds do smart things with money? 0. I'd say no offense to my 19, 20-year-olds out there. I'd say, but you know what? This is my only opportunity ever to buy a $90,000 car. Let's see. They go to the Maloof. Goes, hey, listen. Do you have any I have $90,000. Do you have any $90,000 cars here? yes, we happen to have one left. But that guy over there is looking at it. You better put a deposit on it right away. That was a Simpsons episode from some years ago. Homer gets $40,000, so he goes to the dealership. Do you have any $40,000 cars? Yes, we happen to have just one left. Well, the guy, the car says $30,000. The guy changes it, from 30 to 40,000. Here, we happen to have one left, 39,999. But that other guy's looking at it right away. So,
Hey, Ken,
yeah.
real quick question. You put together a will, it's all legal, everything you've done is what you've said has to be done. Can that will be challenged under
Anything can be challenged.
No,
But-
successfully.
Oh, very, very rarely.
Okay.
Because, see, there is a burden of proof upon the challenger to prove that either the will was done wrong, the person was, I use the word insane when they did it, or there was undue influence. So I will not do a will unless I am satisfied that it doesn't smell. I'd rather not take the money than do it. So, for example, this gentleman, he did a will for us. Everything went to his kids. Then he's an older gentleman. He gets married to the Polish or whatever country the lady was from. And then he goes, you know what? I want to put something in, redo my will and give her 10%. Okay, fine. And then a couple years later, he goes, she's living with me and she's helped me out, getting around, and he had difficulty getting up the steps. I want to give her 30% and my other kids, 7. Okay, that's fine. Then last year he calls up, he goes, I can't come in, but I want to leave everything to her. And he's 90 years old, and he goes, well, I want to pretty much guarantee that those kids are going to challenge that. And I goes sir, you can go to, I am not going to do that because that's contrary to what you would decide. You can go to any other lawyer except for me and the other lawyer here. Not going to do it because we know it's going to be challenged, and I know that there's going to be a problem down the road. Now, some people you mention times where I am the executor. Some people goes, listen, I don't have anyone in the United States. It's all going to charity, whatever. Okay, fine. Someone says, listen, it's going to go, but I want you to be there's a difference. If someone says, I want you to be the trustee, I got to decide, do I want to be saddled with something for another 20, 30 years? I don't know. I don't want my grandkid to get the money until they're 40 years old. How old are they now? 10. Doing the math, that's a 30-year-old long thing. I'd say, let's see, will I be sitting in this desk in 30 years? Listen, what I'm doing now, I don't do anything, I'm trying not to do anything that's going to aggravate me or really stress me out. Let's see, but I remember an attorney Metuchen, he was the trustee, and I'm sure he regretted doing it because the reason why they set up a trust because the one family member had mental issues, and the attorney's son kept on finding the guy in the dumpster, and or trying to sleep in the basement of the building, and I remember at first I thought he was being mean. He goes, hey, Bruno, I said stay out of the building, get the hell out. At first I thought he was being really mean. Then I found out this is a common thing. So I always go, okay, do I want almost like free aggravation for another 20 years? It depends. Okay, everyone, can you turn that off, please, Camille? Thank you, everyone. You have a